solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help me God.
Yes.
Mr. Ballin, please heard us. Mr. Evans, stand your here as you plead guilty to Bridget, please. Aggravated in nature, which period, up to 10 years, is that right?
That's correct.
Is that your understanding, sir?
Yes.
You've had a chance to discuss this with your attorney, Mr. Barr,
Yes, ma'am.
and are you satisfied with what your attorney's done for you?
Yes, ma'am.
You're not under the influence of any drug or alcohol.
No, ma'am.
Anyone promised you anything to try to get you to plead guilty?
No, ma'am.
Has anyone forced you, threatened you, or coerced you in any way?
No, ma'am.
You understand you're waiving some constitutional rights when you enter this plea today.
Yes, ma'am.
You have a constitutional right to remain silent. If you decided to go forward with the trial, no one could force you to testify. If you chose not to testify, Mr. Bell, nobody can hold that against you. When you enter this plea today, you're waiving that right. Do you understand that?
Yes, ma'am.
You have a constitutional right to a trial by jury, where 12 citizens decide whether you're guilty or not guilty. When you enter this plea today, it means you're waiving that right to a jury. Do you understand that?
Yes, ma'am.
If you had a trial, the state bears the burden of proving you guilty beyond a reasonable doubt. All 12 jurors have to agree that you're guilty before you can be convicted. You waive those rights today.
Yes, ma'am.
If you had a trial, you also get the chance to confront witnesses for the state. They would testify in open court. They'd be subject to cross-examination where your attorney gets to ask them questions. He could present a defense on your behalf, and he could subpoena witnesses to come to court and testify in your case. Again, you waive those rights today. Do you understand that?
Yes, ma'am.
Mr. Bell, understanding all of your rights, sir, are you pleading guilty or not guilty?
Thank you.
Okay, if I can get the facts.
Your Honor, on October 8, 2020, Williamsburg County Sheriff officers received a complaint of a male being irate and acting out at the location of 71 Buttercup Road, which is in the Saltus area of Williamsburg County. They met with a Miss Veronica Bell, who advised that her husband, Mr. Ronald Bell, was not acting like himself and that she believed he had been using narcotics. Deputies were advised that Mr. Bell was located in the rear bedroom of the residence and was invited into the residence by Mrs. Bell. Deputies walked to the rear of the residence and they observed Mr. Bell standing by the bed in the rear of the bedroom. They made contact with Mr. Bell, and upon so, Mr. Bell got very irate and asked, "What are you doing inside of my house?" Mr. Bell would not allow deputies to speak and continued to use profanity and yell. Mr. Bell continued to yell and made several threats at Deputy Lee, specifically that he was going to have him fired, and stated that Deputy Lee was going to have to kill him. At this time, Mr. Bell was told to place his hand behind his back and that he was under arrest for breach of peace, which he refused to do, so he backed up against the counter in the kitchen. Mr. Bell also proceeded to snatch Deputy Wetzel's handcuffs from him, and he attempted to run forward and slam Deputy Lee into the refrigerator and push Deputy Wetzel into the chest area.
Are those facts true, Mr. Bell?
Yes, that's true.
Okay. Anything you want to disagree with about the facts?
No, I'm not going to disagree with nothing.
I do find that there's a sufficient factual basis for me to accept your plea, sir. And I find that you're entering your plea today freely and voluntarily, understanding your rights, and with the advice of Mr. Barr, who's a very competent attorney. You've got 10 days from today's date if you wanted to appeal. Mr. Barr, glad to hear from you.
Yes, Your Honor. Yes, this is Mr. Bell. Your Honor, he achieved something on that day that most of us dream of. He had actually paid his house off, and he was celebrating, and he admits that in his celebrating that moment, which I believe I'll get to that moment in the year 2051 based on my refinance, he was just celebrating. He might have had a couple too many adult beverages, and it was just a moment in time that he regrets, and he just sincerely wants to move forward. He's a good man, a hard-working man, and we believe that the state's offer, time served, is fair.
What was the time that it served?
1 day.
Well, it sounds like it was not your finest hour, but you seem like a real nice fellow here today. Hopefully that was just, we caught you at a bad time. Congratulations on paying your house off. I'm going to go along with the recommendation of 1 day, giving you credit for the day you served for a time served sentence. Good luck to you.
Thank you.
Thank you.
Place your left hand above the raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God.
May I please report?
Yes, sir.
Your Honor, before you is Larry Davenport. He's waiving presentment to the grand jury and pleading guilty on indictment number 2021 GS 45 123 to 1 count of possession of a controlled substance 1 through 5. The offending substance being Xanax. The state's recommendation is a 6-month sentence suspended to probation, and the conditions in that probation be placed to help him get some kind of drug treatment. He's represented by Kimberly Hodge of Williamsburg County Law.
Report been sworn?
Yes.
Okay. Report, I'm Judge Curtis. Sir, I understand that you're here today to plead guilty to possession of a controlled substance, first offense, which carries, I believe, up to 6 months. Is that correct, Mr. Anderson?
That's right.
Is that your understanding, sir?
Yes, ma'am.
You've had a chance to discuss this with Ms. Hodge,
Yes, ma'am.
and are you satisfied with what your attorney's done for
Yes,
you?
ma'am.
You're not under the influence of any drugs or alcohol today. Has anyone promised you anything to try to get you to plead guilty?
No, ma'am.
Anybody forced you, threatened you, or coerced you in any way?
No, ma'am.
Your case has not yet gone to the grand jury. After I take your plea today, it means your case will not be presented to the grand jury. You will waive that right. Do you understand that?
Yes, ma'am.
You have a constitutional right to remain silent. That means if your case went forward with a trial, nobody can make you testify. If you chose not to testify, nobody can hold that against you. When you enter this plea today, you're waiving that constitutional right to remain silent. You understand that?
Yes, ma'am.
You have a constitutional right to a trial by jury, to let 12 citizens hear the evidence against you and let them decide whether you're guilty or not guilty. Of course, when you enter this plea today, you're waiving that constitutional right. You understand that?
Yes, ma'am.
If you had a trial, the state would bear the burden of proving you guilty beyond a reasonable doubt. And all 12 jurors have to agree that you are guilty before you can be convicted. You waive those rights today.
Yes, ma'am.
When you have a trial, you have the opportunity to confront the witnesses for the state. They testify in open court, they sit right in that witness stand. Your attorney gets to ask them questions on cross-examination. She gets to present a defense on your behalf. She's able to subpoena witnesses and compel your witnesses to come to court to testify. You waive each of those rights today when you enter this plea. You understand that?
Yes, ma'am.
This is a possession first offense. You understand if you are convicted of another drug offense after today's date, the punishment would be more severe. Every subsequent drug conviction carries a higher penalty than the one that came before it. Do you understand that?
Yes, ma'am.
Knowing all of your rights, Mr. Porter, are you pleading guilty or not guilty?
I'm guilty.
Okay, I'm getting the facts from Mr. Anderson, and then I'll have a few more questions.
Your Honor, on the 13th of June of this year, Officer Dunmore responded to 12 Azalea Drive in the Hemingway area of Williamsburg County. When he arrived on the scene, he arrived there in response to an assault. When he arrived there were two small children in a single cab Ford F-150 looking out the back glass and not buckled into their cars. He approached the vehicle and observed the person he was there about, Mr. Porter. He was refusing to exit the vehicle and acting in an aggressive manner toward county units. Refused to exit the vehicle. Eventually, he did get out of the vehicle without incident. They'd had a prior incident with him, were familiar with him. They arrested him for the assault and battery third that basically they were called out about. They searched him in instance to that arrest, and there was a packet of cigarettes, there was a single green pill, which was Xanax, and there was a clear rock-like substance, which is going to dismiss as part of this plea today. Mr. Porter, like I said, had a magistrate level assault charge, and that's still going to be pending. We're not dealing with that.
Are those facts true, sir?
Yes, ma'am.
Okay, I do find that there's a sufficient factual basis for me to accept your plea. And I find that you're entering your plea today freely and voluntarily with the advice of your attorney, Ms. Hodge, a very competent attorney. You've got 10 days from today's date if you wanted to appeal the conviction. Ms. Ms. Hodge, I'm glad to hear from you.
May it please the court, the defense would just ask you to take into consideration the recommendation from the state and allow Mr. Ford to be placed in a short-term probation. He's indicated to me that he's not been in any trouble recently besides this incident right here with the running of the law.
No prior record?
Your Honor, he has a burglary from back in 3rd, the accompanying grand larceny in 2016.
I'm sorry, I didn't hear that.
Something contraband?
I'm going to go along with the recommendation, Mr. Court. The sentence is 6 months. I'm suspending that to probation for 1 year because we need to have sufficient amount of time for you to have some counseling. I'm requiring random drug and alcohol testing and substance abuse counseling during the period of incarceration. I've seen a lot of good people really take a nosedive with Xanax. Kind of turns you into a zombie. It's very dangerous when you combine it with alcohol. People things like drown in their own shower when they combine the two. It can be very dangerous. So this is the time really to get a handle on this. Take advantage of this counseling. I just don't want to see anything bad happen to you. And there's only one way it's going to go, and that's jail, hospital, mental institution. There's only one direction when you have Xanax is highly addictive. So let's try to get you straightened out this time around and not get back into the cycle, coming back and forth to court. Good luck to you, Mr. Ford.
Thank you, Your Honor.
You saw this swear to occur in a front, so the whole thing, nothing but,
Okay, this is Mr. Taylor. Mr. Taylor, I understand that probation has brought this violation case against you. You're represented by Ms. Hodge, is that correct? Okay, I'm going to hear from probation and then I'm going to hear from your attorney.
May it please court, Your Honor, before you is Mr. DeAndre Latrell Taylor, who was sentenced here in Williamsburg County on September 21st, 2016 by the Honorable Howard P. King. He was sentenced under indictment number 2014 GS 45153, the offense of common law strong arm robbery. He was given a sentence of youthful offender not to exceed 3 years, suspended to 18 months probation. Special conditions required that he obtain his GED, pay $643.75 surcharge to include the public defender fund, court costs and assessments to the Williamsburg County Clerk of Court at the rate of $36 a month, beginning October 21st, 2016. A violation warrant was issued on March 16, 2018, and served on January 24, 2019. That date of 18 is incorrect. For the following violations: the offender had failed to report as instructed and had not reported since October 18, 2016. He had failed to pay the supervision fees and drug test fees as required by the department, and is currently $920 on arrears on the 2 accounts. He had failed to pay the public defender fund the surcharges ordered by the court and was $521.75 in arrears at the completion of this form. However, as of July 21, 2021, he paid the fine balance in full. He's failed to show proof of obtaining a GED or high school diploma due to non-reporting status. He thereby failed to follow the advice and instructions of the agent, and he signed the conditions indicating that he understood them and blatantly refused to comply. Those are the violations as they pertain to this case. He is represented by Ms. Kimberly Hodge of the Williamsburg County Public Defender's Office.
Mr. Taylor, are you admitting or denying the violation, sir?
I'll admit it.
Ms. Hodge, I'm glad to hear from you.
May it please the court, Mr. Taylor is standing before us this morning. I'm 20 years old from Hood City. well, not pending, but the charge that's on his record. He was originally placed on probation back in 2016. And I can tell the court since 2016, he's indicated to me that he's not gotten in any trouble since that original charge for the original probation. Prior to, or while he was placed on probation, he told me that he would always report, he would take a drug test, and he would pass a drug test.
Let me stop you because I'm showing the supervision began on September 21st of 2016. And the report says he hasn't been seen since October 18th of 2016. So, I mean, I'm showing he showed up one time, and I'm guessing there wasn't a requirement to report between September and October.
There was.
So he showed up between September and October of 2016, and then you never saw him.
He never saw me.
Okay.
I'm sorry about that. Sorry. But he indicated to me that he thought probation was, I guess, over after the fees were paid.
I think he's telling you a story. There's no way he thought probation was over. Please don't insult our intelligence, okay? There's no way that he thought probation was over after you reported twice, 3 times, for 1 month. You knew probation wasn't over. And you didn't pay the fines till July of this year, like yesterday. So you couldn't have thought probation was over when you paid your fines. You hadn't paid the fines yet. What else has he got?
Just that he's not gotten any trouble since 2016. He's indicated to me that he would be able to pay off the rest of the fines by the end of August. And we would just ask that the court terminate his probation and convert the fines that are still outstanding to civil judgment.
There's no way I'm terminating the probation under those circumstances. I will say you do have it going in your favor. If it's true that you have not gotten in any other trouble in 5 years, is that the case?
That is, well, to our knowledge.
Well, you would know if you had any further arrests.
We run a rap sheet, but there's nothing on the rap sheet. But all agencies don't report information on to SLED once they arrest them. A lot of information could be missed. It could go in.
Spelling first name D-E-A-N-D-R-E.
Yes, ma'am.
Okay, I'm just looking on the public index. I do not see anything in Clarendon County, in Florence County, in Georgetown County, and the only thing I see in Williamsburg County is the 2014 charge. So just looking on the public index, I'm not seeing anything.
And I misspoke when I said we served warrant in 2019, we served in January 2020. We've got so many people I do not remember.
How did they find you, Mr. Taylor?
I was in Lake City and I was with my cousin and my aunt and them that called the police. So my cousin when they got into a fight and stuff like that, and they asked for everybody ID.
This is a real conundrum. We had a serious charge back in 2014. We got a great deal, equal offender. You haven't done anything required for probation. I mean, the whole thing about probation is you have to report. I mean, that's the main thing. Whether you pay your fines or not, usually they're going to work with you if you're reporting as instructed. However, the purpose of probation is to keep you on the straight and narrow and to keep you from getting in any further trouble. I don't have any reason to think that you're telling me a story. I don't see anything that indicates you've gotten in any other trouble, really since 2014, which is a pretty long stretch now that you've stayed out of trouble. Can we continue him on probation? I mean, I know his period of probation was supposed to end in 2018. Can I extend his probation with basically zero tolerance for any missed report dates.
It can be extended, but time would have to be told in the interim between 2018 and 2021 in order to give us enough time to actually add on the end.
Well, I guess what I would say is, here's what I want to do. You tell me if I'm able to do this. I would like to extend your probation basically for a period of 1 year from today. You do what you're supposed to do. You report as you're supposed to report. You keep doing all the things you're apparently doing now. And if you do that for a year, the probation will terminate. But zero tolerance for you not reporting. You've got to report as instructed during that period of time. You're living in Williamsburg County now?
I live in Lake City.
Is that Georgetown?
Lake City is Florence County.
Florence County.
And from what he said, he's never really lived in Williamsburg County.
I'm fine for probation to transfer to Florence County. Is that, can we make that happen?
Yes, ma'am.
Told the time in between, you get 1 year of probation, zero tolerance for not reporting. If you're doing what you're supposed to be doing and you're staying in contact with your probation, you're not going to have any trouble. They've got plenty of other people to worry about. They're not doing what they're supposed to be doing. You do what you're supposed to be doing, you're going to sail through the probation. You're the one not causing trouble. I'm taking a chance on you, Mr. Taylor, because you've gone this very long stretch without getting in trouble. All right? You keep that job, keep working, keep doing what you're supposed to be doing. Okay, thank you. Good luck to you.
Place your left hand on the Bible, raise your right hand. Place your left hand on the Bible. I'm sorry. I'm sorry. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
May I please start your honor?
Yes, ma'am.
Before you is Ms. Kanisha Rayshawn Scott. She is here on case number 2020 GS450177. She was charged with use of vehicle without permission. She's before you plead guilty this morning. She is represented by Mr. Virgil Barr of the Williamsburg County Public Defender's Office, and the state is recommending a $500 fine plus court costs and fees.
Okay, and I think Ms. Scott has already been sworn.
She has been.
Ms. Scott, you're here today to plead guilty to use of a vehicle without permission, is that correct?
Yes.
And can I get y'all to hand up the plea sheet in the back? Ms. Scott, you've had a chance to discuss this with your attorney.
Yes.
Are you satisfied with what Mr. Barr's done for you?
Yes.
You're not under the influence of any drugs or alcohol today?
No.
Anything to keep you from making a good decision today?
No.
Has anyone promised you anything to try to get you to plead guilty?
No.
Has anyone forced you, threatened you, or coerced you in any way?
No.
You understand you're waiving some constitutional rights when you enter this plea.
Yes.
You have a constitutional right to remain silent. If your case went to trial, nobody could force you to testify. But when you enter this plea, you're waiving that constitutional right. You understand that?
Yes.
You have a constitutional right to a trial by jury. To let 12 citizens hear the evidence against you and let them decide whether you're guilty or not guilty. But you're waiving that right today when you enter this plea. You understand that?
Yes.
If you had a trial, the state would bear the burden of proving you guilty beyond a reasonable doubt. And all 12 jurors would have to agree that you were guilty before you could be convicted. You waive those rights today, and you understand that.
Yes.
If you had a trial, you would also get the chance to confront the witnesses for the state. They would testify in open court. Your attorney would get a chance to ask them questions on cross-examination. He could present a defense on your behalf, and he could subpoena witnesses to come to court and testify in the case. You're waiving those rights as well, and you understand that.
Yes.
This offense carries Up to 1 year is my understanding, and that's your understanding as well. And knowing all your rights, Ms. Scott, are you pleading guilty or not guilty? Okay, let me hear the facts from the state, and then I'll have a few more questions.
Your Honor, on August 16, 2020, Deputy Wetzel and Investigator Brandon McCants from the Williamsburg County Sheriff Office responded to Washington Street in the Hemingway area of Williamsburg County in reference to a motor vehicle accident. When they arrived on the scene, a red in color Infiniti G35 bearing North Carolina tag number DFR9607 had collided with a tree at the address of 108 Washington Street. Officers spoke with witnesses on the scene who stated that they saw Ms. Scott outside of the driver's side door after the collision. Later on, investigators received a phone call from EMS stating that Mr. Dario Coulter was found in a bump of the vehicle. He had suffered a major head laceration. He was stating that he was attempting to stop the car and to take the car back from Ms. Scott, and that is when his arm got stuck in the vehicle and he was dragged alongside the road. While on the scene, investigators also saw tire tracks that were found in the vehicle in a grassy area where it looked like the tire spun, and the tracks continued to that tree that the car collided with possible scrape marks on the ground. Investigator McCants was advised by Mr. Coulter before being transported to the hospital that he tried to take Ms. Scott home, but then he got into a verbal altercation. He ended up leaving up the car. She jumped to the driver's side of the car. They also spoke with a Ms. Sumter, who was located at 108 Washington Street, who stated that she saw that Dario Coulter was laying in the roadway and the female Ms. Kanisha Scott was the one that was driving the vehicle and then flee on foot.
Are those facts true, Ms. Scott? Okay, I do find there's a sufficient factual basis for me to accept your plea, and I find that you're entering this plea today freely and voluntarily, understanding your rights, and with the advice of Mr. Barr, certainly a very competent attorney. So I will accept the plea. You have 10 days from today's date if you wanted to appeal the conviction. Mr. Barr, I'm glad to hear from you.
Yes, Your Honor. Ms. Scott and I talked about this in depth. We've had a couple of weeks to go over this. We do agree with the plea. We were only asked that Ms. Scott be given at least 6 months to be able to pay the fine and the applicable court costs that come with the fine.
Okay, the sentence of the court is 60 days suspended to a fine in the amount of $500. I'm going to give you 6 months in which to pay the fine. It's going to go up once they add the required assessments and costs to that. So as long as you pay that fine within the 6-month period, then there's no jail time. The only time the jail time will come into play is if you disappear on us and you don't pay that fine. Any credit that I need to give her on my sheet for any time she's in jail? All right, good luck to you, Ms. Scott.
Thank you.
Christian News TY would like to thank you for watching. Please share.